Vehicular crashes, hey, they happen. And that's what brings us to this week's case. Involves a case that arose in Southern California. Supermarket down there, Ralph's Supermarket, operated 18-wheelers delivering various produce to their stores in that area. There was a man driving a pickup truck, driving down a highway, and in front of him was a Ralph's delivery truck. But it wasn't a delivery truck, it was an 18-wheeler. This 18-wheeler had been pulled off to the side of the road on what appears to have been a very large road with a big paved shoulder. The driver pulled off to the side of the road to have his lunch. Not an emergency, just to have his lunch. He's out there having his lunch in an area where no parking is allowed. He's there, and along comes the pickup truck. Pickup truck, unfortunately, begins to drift out of its lane of traffic. It drifts out of its lane of traffic and bam, slams into the 18-wheeler. The man driving the pickup truck died. His heirs sued Ralph's Supermarket, saying the driver should never have parked there. It was an illegal parking area. He shouldn't have parked there. Parking was not allowed, but yet he did that. When he did that, he was responsible for the accident. Well, it went to trial, jury heard the case, and under California pure comparative negligence, the jury found that the driver of the pickup truck was 90% at fault and the owner of the 18-wheeler was 10% at fault. Therefore, the owner of the 18-wheeler had to pay for 10% of the damages caused by that accident, by that crash. Well, the guys who represented the supermarket weren't happy, and they took the case up on appeal. Went up to the California Supreme Court. California Supreme Court looked at it and they said, you know what? That jury got it right. And under California pure comparative negligence, where you just compare the negligence of all the parties involved in a crash to each other, we find that they got it right. The man who was eating his lunch had illegally parked his 18-wheeler on a paved shoulder. That shoulder was designed for emergency uses. In this instance, it wasn't an emergency. He was simply parked there. And the reason the paved shoulder was there was in the event somebody ran into a problem on the roadway, they could pull off. Now, in this instance, yes, the majority of fault lies with the man who we don't know why allowed the truck to drift off the roadway and slam into the 18-wheeler. But on the other side of the coin, he would have never hit the 18-wheeler if it hadn't been there. Therefore, the 18-wheeler was a substantial factor in causing this crash. Okay, what's the point of this? The point of this is pretty straightforward, and that is that even when somebody is not actively involved in doing something, they can set the scene for injuries that will come about because of what they did. Is it foreseeable that somebody would drift off a highway? Is it foreseeable somebody would start to pull off a highway as a result of an emergency? Absolutely. And that's why it was illegal to park there, and that's what the court found. You may like it, you may not like it, but that's the law. And we bring you the law every week here on these video blogs so you understand how the law works. I'm David Allen.